Good afternoon to all of you, and congratulations to Jan for this great conference, and thank you very much for the invitation. I must tell to the audience that I originally declined to come here because I already knew that I wasn't able to submit an original paper, but Jan was generous enough to tell me that I could submit something that was already in publication, and I'm glad of coming here because it is a great opportunity at least to exchange some ideas on a project paper that builds upon the text I have submitted. The project paper has a rather pompous title, which is Living Originalism in Europe. And the goals of the paper are basically three. The first one is to try to reconstruct a trajectory from a context in which the original principles of European constitutionalism could shape legal and political life in Europe, in a context in which supranational cooperation was conceived of as enhancing national constitutions, to a situation in which, because of a neoliberal drift of supranational law, those principles are undermined, or at least are interpreted in a rather, at least for me, regressive way. And the second goal of the paper is to try to see what has been the role of constitutional language in this trajectory. What is the role? Has constitutional language played as an utopia or as an ideology? And the third point, I would like to use the notion developed by Yale professor Jack Balkin, Living Originalism, to see whether this can be useful to try to promote, to trigger some element of constitutional self-government in contemporary Europe. Now, the paper, or the project of the paper, starts by setting out 4 principles that I call the original principles of European constitutionalism. And the 4 principles are the following. The first one is that constituent power is regarded as popularly legitimated, and therefore the Constitution is conceived of as a social norm, as a norm that is the result of an open compromise between otherwise conflicting political and social forces. The second principle is that the principle of human dignity. Here I draw a lot from what Sasha Zonak has written in his penultimate book, or The Cosmopolitan Constitution. I have lost track of the books. In which human dignity is presented as a principle that, of course, protects individuals from governmental encroachment, but most of all is a principle that protects the individual from the vagaries of unregulated market. The third principle is political freedom, the possibility for political parties to develop constitutional ideas into alternative and possibly conflicting policy goals, courses of political action. And fourthly, the idea that constitutions are open to international and supranational cooperation. So altogether, these are seen as the qualifying elements of European constitutionalism, of course, as developed in the aftermath of World War II. Now, these 4 principles have been able to shape legal and political life for a long time, for all the period up to the constitutional moment that in the previous panel was identified at the end of the 70s. At the end of the 70s, the reality changes. We have this neoliberal drift with the end of the type of multilateral arrangement that they used to apply at the beginning, in the foundational period of European integration. the foundational period of European integration, we have a multilateral institutional framework relying on the idea of embedded liberalism. With the end of the 70s, this changes and embedded liberalism declines, and we have this neoliberal drift. This neoliberal drift has a number of consequences that in the paper I would like to spell out in detail. For the purposes of our discussion, I will single out two of them. The first one is that the institutional setting of the European Union, or the European communities at the time, expands in its reach, in its scope, and it expands in order to pursue a single policy agenda, which is not contradicting per se the original objectives of constitutionalism. It provides a specific interpretation of those objectives, but critically what happens is that that interpretation is entrenched. It is entrenched in the treaties, in particular in the policies and the competencies assigned to the European Union. The second aspect I would like to stress is that this policy agenda is promoted by the European Union with a view to co-opt national policy makers. The relationship which is developed between supranational law and national policy makers at the times is very much similar to the one we see envisaged in the German constitution in Article 83, in which the Bund develops the policies and the Länder are required to apply, to implement, to do the implementing work. Of course, they are represented in the Bundesrat, as in the European Union we have the states represented in the Council, but still we have an idea of commandeering that applies in EU policy making. Now, what is the role of constitutional law, or better to be said, of constitutional language in this process? Has it worked as utopia or as ideology? Now, I would like to make a nuanced argument. It worked in both ways. In particular, there are policy fields in which constitutional law worked as an utopia. If we think about the expansion of competencies on area of freedom and security of justice, constitutional language there has operated and operates as an utopia, as something to be achieved and something which is regarded as a progress, as an idea to transfer, to convert the EU institutional framework into something very much similar to the type of constitutionalism we have at national level. There are other fields in which the role of constitutional language is much more ambiguous. There are fields in which constitutional language has basically operated in ideological ways, and I'm referring to the common market, to some extent also to the European Monetary Union. Constitutional language there is used as a pacifier. Is used as a pacifier for the, of course, this is something we know as constitutional lawyers, for the constitutional courts. It was the language that was employed to have constitutional courts to accept the supremacy of EU law. But it has worked also very well on the political dimension. We can argue that the constitutional language was something that was used to pacify the political left from opposing the neoliberal drift. The idea of a pan-European constitutional democracy was offered in exchange of an agreement to the expansion of this project. Of course, we never reached a genuine pan-European constitutional democracy, or at least a pan-European constitutional democracy with the same democratic and social credentials of those we expect at national level. And the crisis, the financial crisis, has amplified both the neoliberal drift and the ambivalence of constitutional language. It has radicalized all the claims and the entrenched policy agenda of the Union. Financial stability and competitiveness have become the overriding goals of the European Union. And constitutional language has operated in an ambivalent way again. on the one hand, it has revealed a subversive role. There are many people, many scholars, who have said that constitutional languages should be used to upset the institutional framework that the European Union is trying to develop and to enforce. So the idea, at least in my perspective, the utopian idea has been rehabilitated in this type of arguments. But also the constitutional language has been used as ideology. Again, if you look, for instance, the initiative of the European Commission, the European Pillar on Social Rights, is trying to use constitutional language again in order to secure the sustainability of a project that has not much to do with a genuine protection of social rights. So we end up being in a situation which is very interesting, because we have the same principles, the same constitutional principles being used on the one hand by those that would like to redeem constitutional language, and on the other by those who would like to use constitutional language to secure the status quo. And it is an interesting debate, I think, because it is the embryo of something that in America could be regarded as constitutional self-government. The same principle being the source for different opposing political interpretations of the same principle, while retaining the same principles. So there is an element of conflict, but a conflict which is contained within a shared institutional framework. Now, the problem we have, and the problem in which the obstacle we have to have this type of living originalism, this idea of retaining the principles of the past in order also to shape the future, is that we don't have a precondition that the American Constitution offers, an open institutional framework. The institutional framework of the European Union at the moment is not open. That's why in order to have living originalism in Europe, what we should do is to implement a set of reforms to open up the institutional framework. I conclude the project by listing a few of these reforms. I will just tell them, and perhaps in the debate I will elaborate on them. The first is to stress the centrality of Article 2 of the Treaty of the European Union rather than Article 3, so more the values than the objectives. The idea is that we should shift to use the language used also by Neil Walker in his paper, from a teleocracy to a nomocracy. The second proposal is to deconstitutionalize the treaties. We could do sufficiently with the competencies. We don't need policies in which policy directions are entrenched. We should have competencies, but in those competencies we should be open to have diverging policy directions. And then we should have elements to re-embed the market at supranational level. For instance, to have legal basis to harmonize taxation with qualified majority voting, or working conditions, in order to reduce the scope for regulatory and tax competition. And finally, in highly salient policy fields, we should shift from the idea of commandeering to a different idea, which is again an American idea, the idea of conditional spending programs. We should say to member states that in highly salient policy fields, economic policy, social policy, perhaps immigration, that the European Union offers certain programs with also some carrots, some fundings, and member states are free whether to opt in or opt out in those fields. This would, on the one hand, preserve some degree of cooperation, of constructive cooperation, on the other hand, secure also a level of self-government. And I will stop here.
Two questions. One is this notion of living originalism and your observation that contrary to the US, the constitutional framework in the EU cannot be changed that easily. But as I understand it, Belkin developed this concept precisely because what is understood in the United States is that they can't change their constitution either, right? And the second thing is about the reforms. And I'm just wondering why you have this list of things while I know what you know about the political economy of the European Union. So, for example, yes, re-embed markets at the European Union level. Let's put it into the qualified majority voting. But we know that now the states are so different that simply, even with qualified majority voting, they can't agree on certain things, like varieties of capitalism and all of that. So that's one question. And the second, moving from commandeering to sort of incentivizing the member states to do what. Who wants that? Who decides that what the desirable goals are? So does it make it more legitimate that Brussels, if I translate it into the language which I could hear in my country, that Brussels decides that we need to take more migrants so that we can build our roads, so that more goods can be, moved to the Czech Republic? Is that the deal, and does it make it more attractive? So 2 points.
Can I reply to this?
Sure.
So the idea of I'm not saying that we need those reforms and live in originalism because it is difficult to change the treaties. I think that the problem is that it is interesting for a political community, a supranational political community, to have shared objectives developed, shared values developed, interpreted in alternative ways, in order to stop to have discussion about the container and discuss about the values and the policies we would like to have. At the moment we have a lot of discussion about the container. For good reasons, because the container is biased. That's why I propose those reform. The container is biased. We should have an open institutional framework in which alternative courses of political action are possible. And they should be possible both at supranational and at national level. Now, interestingly, the proposal is not meant to resolve the problems of the European Union. It is meant to resolve this specific problem, to have an open institutional framework. That it's up to politics to try to, for instance, achieve the majorities needed to harmonize taxation, to harmonize corporate. This is not the job, the task of a constitution. The constitution has to offer instruments, for instance, for those. But the idea of either harmonized taxation or have tax competition remains for the political authorities. And on commandeering, yes, I think it's more legitimate from a democratic perspective to tell countries, look, here is what the European Union offers. Here are fundings for certain activities, but if you want fundings, you have also to accept certain burdens, certain you have to cooperate in certain other projects. It's up to you. If you want those fundings, you have also to help us on other issues. And I find it much more legitimate than the current situation in which the European Union could decide you have to accept, you have to implement this policy simply because you are in a minority in the council.
Can I comment?
Yeah.
Okay, I have 3 people on the list. I think we can...
Yeah, it's a very brief question, and it basically repeats something that Jan has already said. The European Union is has become very heterogeneous. Yeah, north, south, east, west. With Austria now joining the east, actually. Very interesting. Many of the things that you have put on your list would require treaty change. How can we get to the treaty change? Do you have an answer to this question that I cannot answer?
It's not my job.
Yeah, okay. This was my question.
I think we might take a few questions. Thierry?
Okay. Thank you very much. It's amazing, this shift from objectives to values. So Article 2 should take precedence. Aren't we actually heading for a big trouble here if we start saying what are European values? Because at the moment it's populist parties that speak about values most, and it's not values. So I'm sorry to repeat Weber here, but if we get into politics of values, we get into the war of gods. Yeah. And the major success of European Union historically was that it depoliticized these war of gods. Yeah, that what is more valuable, and so, and I'm playing almost I'm arguing against
Devil's
myself.
advocate.
I'm arguing against myself here. Yeah. So, isn't it a dangerous game of flaming up the wars of the values in which Orban will stand against Merkel, and they will be fighting about European values?
But it's restating values that, as far as I know, all the member states have subscribed already. And they are the values of the democratic and social state, or democratic and social state.
Yep.
And of course they are, but those values are open to different interpretation. Now, my problem is that at the moment those interpretations are, some of them are out of the container, out of the institutional framework, and are destabilizing the institutional framework. The attempt I would like to have is to have the conversation on those values within a shared institutional framework, to mediate and institutionalize the conflict rather than have a conflict that ultimately could undermine the institutional framework itself.
And is prosperity a value or an objective?
Okay, it's Calypso. You can think of it.
Yeah, it's the other side of the coin that I wanted to come back to after Jan. First of all, on the general living originalism, I wonder how, I mean, if you could defend a bit the label. I use transformative fidelity to the extent that I think originalism is very loaded and is all about founding fathers, and there's no mothers, by the way, Anna, in that story. But that's kind of a very broad thing. So I'm just reacting to your commandeering point, which is otherwise known in the world of international organizations as positive conditionality, very old idea that we should replace negative with positive external conditionality. And then I ask, well, isn't the EU precisely all about doing away with conditionality, starting in terms of trade law? You know, you go from anti-dumping to competition law. That's kind of the point. You're building a polity that's not based on reciprocal behavior as formalized under GATT and WTO and other IOs. And so one question is, you know, how hard are we thinking when we go back to this logic that the union was precisely built against? And the bigger point there is that, and it has to do with monetary union, etc., is that, you know, what we're switching from, what we're doing is merging two logics. The logic that we're supposed to be into, with or without constitution, which is polity building, with or without constitution, or formal constitution, versus, you know, the logic of conditional interstate relations with reciprocity and retaliations, more or less constrained and channeled by international law in a different way. Now, maybe that's what the EU, you know, needs, but I find this, you know, part of what is problematic, because of course conditionality is a mix of contract and coercion. And of course, the coercive drift of the EU is what we're kind of after. And I am not sure it resolves the problem simply by switching to positive conditionality from negative conditionality. But I'm not sure. I'm kind of asking, because I think it is a very difficult, I'm not saying I'm sure of what I'm saying. Yeah.
Okay, so the first question, Balkin's attempt is to try to accommodate the originalism and the living constitution approach it's trying to say that basically there are two sides of the same coin. It's the idea that they could not be regarded as necessarily incompatible approaches in interpreting the American Constitution. Now, why is it that I find this interesting? Because it tries to take together two tensions that otherwise in Europe are going to disintegrate the society. On the one hand, those reclaiming back the original constitutional values, the democratic and social state, and on the other hand, those who would like to use those values to legitimate another project which is a project of transformation of those values. I think that there is a genuine democratic discussion to be had between the two, and what is important for constitutional lawyers is to try to institutionalize the discussion. Now, the divergent element, as I said, from the American context to the European is that we don't have, at the moment, the open institutional framework to have this discussion. That's why I formulate proposals. The commandeering point, so it is, of course, loaded as an argument. I would say that in Europe we have the Tea Party in Europe would be social democratic. And there is something, the Social Democrat, the Tea Party in Europe is the Christian Democrat. If you apply originalism to the European Union, you look at the defense of national constitutions is basically claiming back the democratic and social state. By contrast, what was I saying? Yeah, the commandeering point. I'm also thinking about that. At the moment, what we see in highly selling policy fields, economic policy, social policy, is negative conditionality. I'm trying to find a way which is more democratic legitimate than what we have at the moment. At the moment, we have the Troika saying to a number of member states that they should implement a specific policy agenda, irrespective of their outcome of the national elections, of national general elections.
Well, they also say we'll buy your sovereign bonds. You know, there's elements of positive and negative conditionality. Is the distinction negative, positive as important as conditionality or no conditionality? You know, that's what I'm saying. Is that the logic of conditionality? We need to get into it with an open eye, rather.
We have two more speakers or two more questions, so perhaps we could go on to them in order to not run out of time. Agustin?
Thanks.
And Mike.
Provoked a bit by Mike on the question of the why. I agree with constitutional discourse in a way being a pacifier regarding constitutional courts. I would say from the 70s. And then from 1992 is a pacifier of the left, and we discussed that also of the Christian Democrats, I would say. But it's also, from 1992, is also a way of avoiding politics. It fits quite well, in the sense that you have, for example, governance by numbers. We had monetary union, we could not agree on how we related fiscal to monetary policy. The way out of that was rules. Stupid rules, by the way. But it was rules. So in a way, it is also fostered by the process itself, in this funny way. That the more that you go into the process and the more that you have to take political decisions and you are not equipped in order to take political decisions, escaping into a kind of constraining constitutional discourse fits the bill, because it avoids politics.
I suggest that we take the last question from Michael.
Okay, thanks. Yeah, thanks, Marco. I mean, look, it's very easy to sort of shoot down normative projects, but I do want to push you a little bit on your very, very, very quick response to Sasha, which was that it's not my job to change the treaties. Of course, you can't change the treaties, but
to think about.
You set yourself up by saying that constitutionalization is a pacifier, and in some ways what you're offering is simply another pacifier. Whether these particular reforms would change anything at all is obviously debatable. But your goal, you say, is to defend a social democratic Rechtsstaat, which is long gone. I mean, you're talking about the Italian constitution of 1950. Now, to return to that is going to require something more than a set of normative goals offered by an Italian public lawyer in Trento, I mean, however much commendable they might be. So I think my question, which relates somewhat to the dispute we had over the Italian crisis earlier in the year, is for the kind of goals that you're commending, you need radical social movements to have any chance of success in terms of even you mentioned the Tea Party. We don't want the Tea Party, obviously, we want the opposite. But the notion that some kind of normative project like this is going to connect in a way which will change what is required, which is a radical change, seems to me fancy.
Yes,
More than
the answer I would like to give is that the moment in which you try to claim back those principles and to say those principles, those are not just for courts to be applied, but they should inspire political agenda and political debate. You have at least started to have the precondition of that kind of action. I agree with you, you need political agency to achieve those goals. But as a constitutional lawyer, I have a preliminary concern. The concern is that there's going to be conflict in that, and that conflict should remain within an institutional framework, otherwise is violence, otherwise is a situation in which conflicts are played out in antagonistic rather than agonistic ways.